Great to have everyone there in our webcast audience. I'm Terry Maggedy, chair of our Elder Law Committee for the Beverly Hills Bar Trust and Estate section. And the first thing we do, of course, is to show appreciation, which is good, particularly after coming out of Thanksgiving. And our appreciation goes to our sponsors first. And I want to thank them one by one. And we'll start with the Sanborn team. They're all up in front of you on the screen, but I'm going to start with our longest running sponsor, and that's Nancy Sanborn and Brian Joy from Sanborn team. They're real estate brokers, and as with many of the people you see on the screen, they specialize in probates and conservatorships and trusts. And so we really appreciate them for being with us a very long time to help make these programs happen. Second, I think I may put them together because typically they are, which is Bond Services of California and Liberty Mutual Surety. Anyone that works in the probate space knows these folks because they provide top-notch services to all the attorneys and other professionals who are working the probate court. They're just wonderful, and we really appreciate what they do. And thank you, Bond Services of California, and thank you, Liberty Mutual Surety. Next, we have California Title Company, a title company that deals in our space, probates, conservatorships, trusts, specialized issues that are focused on older people or people with disabilities. So thank you, California Title Company. And also Pickford Escrow Company, an escrow company that works in those same areas that I mentioned. And all of us who are professionals in the area, probate, trust, conservatorships, estates, know how important and efficient and just overall, resulting in a great product it is when you're able to work with folks like our sponsors who specialize in our area. So thank you, all the sponsors. And now our program today, we have a great attorney. You can't say enough good things about Liane. Liane, she does. I mean, you could list all the different things she does. Discrimination, all on the employee side, of course. Discrimination, harassment, retaliation, wage, hour, whistleblower claims, all the different potential claims that are affecting employees. But when I say Liane's special because to be in where she is, she has to mix compassion for the folks she represents because she has a relationship with them, and it's very nice and it makes the process better. But on the other hand, as an attorney and advocate for them, she is effective and ferocious. And you let me put it this way: it's nice to have her on your team and not the adverse party's team. So I want to thank her for being here, and the program today is aligned with our niche topics that we're always doing, which are, they're either related to older folks or people with disabilities, but one or the other. Then we delve into, micro areas that affect our population. And today it's the disability population. And so it's disability discrimination and workplace accommodations in California. And with that, I'll turn the program over to Liane.
Thank you, Terry. That was an incredibly sweet introduction. I love being called ferocious. It's wonderful. So just like Terry said, today we are going to talk about disability discrimination and workplace accommodations. Let me share my screen so we can get the slideshow up there. So this is a disability discrimination is a large topic, and you can hit at it from a lot of different ways. You can talk about how you try one, or what the burdens are for proving that an employee's been suffered disability discrimination. Today, we're just going to really kind of hone in and focus on this idea of workplace accommodations. And we're going to focus mostly on California and not on the federal equivalent, though we will go into it a little bit. So that's my bio. That's my law firm. Like Terry said, I represent employees in employment disputes of all kinds, including disability discrimination. Okay. So today we are going to understand the basics of disability protections. We're going to talk about what a reasonable accommodation actually means. We're going to talk about the interactive process, which is really where the meat of these kinds of cases come in. We're going to talk about some pitfalls, and then I'm going to talk about some of the real world cases that I've had that sort of deal with these accommodations. Okay, so why does this topic matter? I think it matters a lot because we have an aging workforce, and the chart sort of shows you, but the number of Americans over the age of 65 is going up, and people are staying in their jobs longer, whether that be because of choice or because financially people need to work longer into older ages, but we're seeing it. And so with that, you end up with sort of chronic conditions. You end up with like mobility issues and stamina and vision and hearing, chronic pain, all of that sort of increases. And then you end up needing to deal with that in the workforce and the workplace. And so that's the first reason why it matters. The second is that there are a lot of chronic conditions that affect a large number of people, in the workforce in California, whether that be arthritis or diabetes, long COVID, post-surgery restrictions and mental health conditions. This comes up a lot, and I get calls about it all the time. The third reason why I think it's important is that I think that these legal protections are misunderstood. And I think that there's a lot of misinformation about what needs to happen to accommodate, an issue, a disability in the workplace. And I think that there's a lot of like anger that employees are faking, or that employers are required to go to great lengths, to try to accommodate, these disabilities. And it's honestly a much, it's not as complicated of a process. And it's something that early intervention can prevent. If you talk to your employees, employers and employees talk, you can really avoid this kind of litigation. Okay. So let's talk about the legal framework. What laws apply? So we're going to focus on FEHA today, which is the California Fair Employment and Housing Act. And that is California's broad anti-discrimination law. So it covers more than just disability discrimination, but disability discrimination is one of the areas that's covered by FEHA. So in order to qualify for FEHA protection, the employer has to employ more than 5 employees. And then the definition of what constitutes a disability under FEHA is that it needs to limit a major life activity. So it's pretty broad. We're going to talk about that. And then there's no caps on damages under FEHA. The federal equivalent, which is really like the baseline, is the Americans with Disabilities Act, or the ADA. And so that's something that all of the states have to comply with. And then California's is more protective. So ADA is the floor, and then California raises it. And under federal law, you have to have 15 employees. So, it starts to bigger workforces that you need for the ADA. And the definition of disability is narrower. So whereas in California, you only have to limit a major life activity, under the ADA, you have to substantially limit it in order to qualify as a disability. So it's a harder standard for what the employee is suffering for it to meet that definition of disability. And then there are caps on damages under the ADA. Okay. So what counts as a disability? So under FEHA, disability is any physical or mental condition that makes it harder to do a major life activity. Okay. So, and that you can look at this case that sort of defines, what that means. And so it's broad. and it uses the word limits. And so it just needs to make that task more difficult. It doesn't require severe or long-term impairment. And again, unlike federal, it doesn't have to substantially limit. Sorry about that. So here are some examples that a disability can impair, and then it would qualify under FEHA. So if what you are suffering makes it harder to walk or lift or concentrate, if your vision is impaired, if your hearing is impaired, anything that makes it harder to do everyday tasks would qualify under FEHA as a disability. Okay, so that would include like arthritis, diabetes, cancer, depression, hearing or vision loss, if you break your leg, if you have surgery and you need to recover, if you're pregnant, if you're coming back after a pregnancy and you're not fully healed, all of those count as disabilities. So once you have a disability and once you find that your disability is making it difficult to do your job, what an employee would ask for is a reasonable accommodation. Okay. And so, listen, I broke my leg. It's hard for me to walk around the office. I need some assistance with that. That's the kind of thing where you would ask for a reasonable accommodation. And so it's just, you're asking for a modification that would allow the employee to perform the essential job duties. Okay. So employee has to be able to perform the essential job duties, no matter what. But if there is an accommodation that allows them to do that, then it's reasonable for the employer to offer it. And so it's really just about enjoying equal employment opportunities so the employee can continue to work safely. So the phrase that you'll see is essential job duties. So the employer isn't required to eliminate the job duties. They don't have to, modify what the employee has to do in order to complete their job, but they do have to maybe provide something that would allow the employee to perform those job functions. And so what does that look like? The kinds of things that I see the most, the kinds of things that the employees who call me are asking for, are like a modified schedule. Maybe they need one day off and one day on. Maybe they want to come in and start their day earlier and leave their day earlier. That's a modified schedule. They ask for, equipment, like an ergonomic chair or a standing desk. I mean, I think those have become pretty commonplace nowadays. A lot of employers offer them, anyway. They're available for employees if they need them. Remote work. After COVID, I think we learned that a lot of jobs that people thought could not be done remotely actually can be done remotely. And so that is something that I see employees ask for, or even like a hybrid situation. Can I come in at the office 3 days a week and work from my home 2 days a week? Another thing that actually qualifies as a reasonable accommodation is reassignment to a different position. Now, one of the main cases on this is this Neiman Marcus case. An employer doesn't have to create a new position, but if there is a position open and the employee is qualified for that position, then it is a reasonable accommodation to at least explore whether the employee can take that job. And so you'll see this a lot, like when someone perhaps has a physical job, like they're out in the field, maybe they're in pest control or inspections of some kind, and they've injured themselves, and there is a desk job, somebody who routes people, to the inspections, or somebody who's doing a less physical job. And if that's open and if the employee is qualified to do it, then that could be a reasonable accommodation. You'll see a lot of requests for like lifting limitations. I can lift, but I can't lift over 15 pounds, something along those lines. And also extended or intermittent leave can be an accommodation. I need to take a few weeks to heal. I might need to take a day or two sporadically, throughout the next 12 weeks or so. And that can be a reasonable accommodation under the right circumstances. And so what does an employee have to say, in order to get that accommodation? Like, what are the magic words? There are none. They can say, I need help because I'm hurt. They can actually specifically ask for a reasonable accommodation. And, employees tend to be a lot more savvy. I think people are pretty well aware of their rights. And so they may use that exact language. I need a reasonable accommodation. Might be my doctor says I can't do my job without X, Y, or Z. But any sort of combination of those words means that the employer needs to act. They need to do something. They now have a duty to respond. They have a duty to interact. And that is another phrase that you hear a lot in the disability discrimination world, which is engaging in the interactive process. So employee comes and says, hey, I hurt my leg. I can't drive. I need help getting to the office, or I need to work remotely. And so now the employer has to hear that and has to engage in this interactive process. And so the employer and the employee need to communicate. The employee needs to lay out, what it is that what it is that they need help with, and maybe even come up with some ideas of how they can be helped. And then the employer and the employee need to share information. The employer needs to explain why something might not be reasonable, and offer alternatives, consider different alternatives other than perhaps what the employee proposed. And then even if an accommodation is given, the employer needs to follow up and make sure that it's working and, that the employee is capable of doing the job now. And so one of the main cases on this interactive process is this Jensen case. And it says that the process must be timely, it must be good faith, and it must be thorough. Okay. And actually failing to engage in the interactive process is its own cause of action under California law. So even if ultimately it would be impossible to accommodate the disability that the employee has brought up, the employer still has to engage. Otherwise, there is a cause of action for failure to engage in the interactive process. So it's important. And so these are sort of the employer's obligations. Respond promptly. I cannot tell you how many cases I think would never have come to me had the employee or had the employer just responded promptly. That delay when an employee says, hey, I need help, that creates so much anger. It gets everything off on the wrong foot. Whereas if the employer says, hey, I hear you, let's talk about it, I think you immediately diffuse things. So responding promptly, very important. The employer is allowed to request medical information if it's necessary and only what is necessary. So that doesn't mean that you get to look at your employee's medical records for 10 years back, from every doctor they've ever seen. But what you could request is a doctor's note. Hey, you're saying that you have this condition, especially maybe a condition that you can't see or that you weren't aware of. You have this condition, can you document it? And oftentimes the doctor will say what they think the accommodation should be, or they will explain what the limitations are. This person can't lift, more than X amount. So I think that doctor's note can be really helpful. Now, if the disability is obvious, there may not be a need to request a doctor's note. If the employee is pregnant and you're well aware of that, you don't have to go and request a doctor's note for that. So some disabilities, that may not be necessary. And so then the employer's obligation is to explore all reasonable options. And then I would say an employer obligation, it's not necessarily required, but I think it's incredibly helpful, is to document the process. So when I get one of these cases, I'm going to request the employee's personnel file. And if my employee is saying, hey, or my client is saying, hey, I brought in a doctor's note, I brought doctor's note in every 3 weeks, I sent emails, I should see that in the file. I should see the doctor's note. Oftentimes I'll see notes from HR saying, hey, we received, John's doctor's note. We told John, we could not accommodate it, but we were willing to offer this. It's very helpful to see that. And oftentimes, if I'm early in a case and I've just requested the records to determine if I'm even going to take that case, if I see that back and forth and I see the employer really tried to engage, I may decide that's not a case I'm going to take. So I think the documentation is helpful for both sides. And then obviously the employer needs to avoid retaliation. discipline, or pressure. Those are going to give rise to additional causes of action. So, that's what the employer has to do when the employee has requested an accommodation. Okay. The employee also has responsibilities. The employee has to also communicate, has to explain what their limitations are. If they're being offered suggestions, they have to explain, or offered accommodations, they have to explain why that accommodation won't work. There is some case law where cases have not gone well for employees because it became very clear that they didn't want the accommodation. They eventually wanted to sue. So, the employee also has responsibilities. Provide that documentation when it's appropriate, participate, try the proposed accommodations. If the employee is asking for one thing and the employer comes back with something different, the employee, if possible, should try that proposed accommodation in good faith and see if maybe that allows them to perform their job duties. Okay. So just because an employee comes and says, I need this accommodation, that does not mean that the employer has to say yes. California uses the term undue hardship, but it is a high standard. It doesn't mean that what the employee is requesting is inconvenient or annoying. It doesn't mean we've never done this before. That's not going to meet the high burden of undue hardship. It means something more serious. It means that it would be either incredibly onerous or impossible for the employer to accommodate what the employee is asking for. And so those kind of come into a few categories. Significant expense, so cost. This one is going to really hinge on the size of the employer and what the employee is asking for. If the employee says, hey, I need an ergonomic keyboard, and you are Amazon and you say, no, it's absolutely too expensive, that's not going to fly, right? But if you are a really small employer and the employee asks for like a very expensive standing desk, or something that does have a high price tag associated with it, that could be too costly, and could actually rise to the level of an undue hardship for the employer. Another one, and probably the one that I think I see the most, is just major operational disruption. You're asking for equipment that would make it hard for people to move around, in the workplace. Something that would really make it difficult for the employer to, continue performing the job. And that could be if you're requesting perhaps extended leave and the employer can't afford to not have someone in that position, because that job is really necessary and they're a small company, then that might qualify as undue hardship. And then the last one that you see is safety risks. If there's no safe way for the employee to perform this job, with an accommodation, then that would be an undue hardship. And so if it's very heavy machinery, or you're in a high risk medical setting, so roles that require emergency response, that could then be an undue hardship and not an accommodation that would be reasonable for an employer to make. Now, if the employer says, hey, can't accommodate, undue hardship, what can an employee do? One of the very first questions that I'm going to ask is, well, are there other employees with similar accommodations? Have they given these kinds of accommodations in the past? I see this a lot with remote work, things like that. It's you can't accommodate this employee, but there are, 5 other employees who work from home. I don't really believe that this is an undue hardship. The size of the employer, you're telling me that you can't leave this job open, but you're huge and you employ 100 people in this position, across the state of California. I don't know if I believe that. Did you just say no right away? Or what steps did you take to try to make the accommodation work? Did you engage in the interactive process? Did you provide fair alternatives? We also look for discriminatory words that went along with it. They called him too old to do the job, or something along those lines. If I've got that coupled with this refusal to accommodate, yeah, that might be a case there. And so the sort of case on this is Green versus State of California. And what it says, though, is that the burden is on the employee. So the employee has to show that they can perform their essential job functions with the accommodation. Okay. So if an employee sues, what are the remedies? So hopefully you never get to this point because hopefully the employee has come, has requested an accommodation. The employer has engaged good faith in that interactive process, and either they've been able to reach a resolution and they've been able to find, some sort of accommodation that works, or the employee understands through the back and forth that there's not going to be something that's feasible. But lots of cases don't end like that. They end with the employee eventually bringing a lawsuit. And when the employee brings the lawsuit, the employee is going to ask for certain things. They're going to ask for reinstatement. I've actually never seen an employee get reinstatement, but it is a potential, remedy that that employee can ask for. Back pay, so the wages that they lost in the past because they were terminated. They're going to ask for that, and they're also going to ask for wages going into the future. They're going to ask for emotional distress damages, which can be hefty. They might ask for policy changes, injunctive relief, ask that the employer revamp, its policies on reasonable accommodations. And then they also can ask for punitive damages. Okay. So I wanted to talk about some actual real world cases that I have dealt with because I think it's more helpful to hear how it plays out in reality. So I had a case where my client was pregnant. It was like a large gas station company. And she was a manager at one of these gas stations. She was a superstar. She had basically been promoted from lowest level all the way up, through the company. She gets pregnant. She is not doing well, super, super nauseous, really, really sick. But she is making it work. She is driving like an hour to get to her job, throwing up all of the way there, but she's making it work. And as she's sort of progressing through the pregnancy, there's some grumblings. You hear some comments about, she's not as like good a worker as she was, before. But then she suffers like a very serious complication with her pregnancy, and she has to go to the emergency room. So she is not able, obviously, to show up for work that day because she is admitted into the hospital, and her doctor is pretty adamant that she's going to have to go out on full-time leave early because of the complications to the baby. And so the doctor faxes over a doctor's note explaining that she's out, she's at the hospital and that she's likely going to need to be on leave through the rest of her pregnancy. And he faxes it to the number that my client had given him. That's the number where you're supposed to send, these sorts of things to HR. Her employer, her supervisor reaches out to her via text. She says, "Hey, my doctor's sending a note. Like, I can't talk. I'm in the hospital." He proceeds to bombard her with texts saying he hasn't gotten the fax. And she essentially cannot deal with that because she's in a medical emergency. She's in the hospital for over a week. And when she gets out of the hospital, they have fired her. And they said, "We never got the doctor's note. So, no call, no show, you're fired." And in that case, the reasonable accommodation was honestly waiting. I think they did get the doctor's note. I don't believe that, but let's say it's true. Let's say the fax machine didn't work or it didn't go through. They understood she was in a medical emergency and waiting for the doctor's note, waiting to understand the parameters of what she was going to be requesting for an accommodation is a reasonable accommodation. And so that's a real world case where I saw that play out. Also had another case where this employee worked in like a doctor's office, and her job was essentially to be the person who got yelled at by patients when they were unhappy with, whatever had occurred during their doctor's visit. And she broke her leg. And so she had to drive a pretty far way to get to the doctor's office, and she couldn't drive. And so she tried to take public transportation, but that was really difficult with a broken leg. And it was temporary. She needed like 6 to 8 weeks probably. And so she asked if she could do her job remotely. And her employer said, no, can't do it remotely. You have to be here. It's an in-office job. We can't accommodate that. And it essentially resulted in her having to quit because she couldn't get herself to work. And under certain circumstances, saying, hey, listen, this is an in-person job, that might be a reasonable response. But in this situation, there were like 9 other employees with the exact same job title that she had, who either worked fully remote or hybrid. And so I just didn't see that as a reasonable accommodation when you're permitting other employees to do the same thing. Seems like the job can in fact be done. The essential job functions can in fact be done remotely. Okay, so that was one case I had. Another case where sort of an accommodation came up was a case where, my client was like a clerk, like a associate in a drugstore. Also had sort of worked her way up, and she was now like I think a shift lead. And she got pregnant, took her pregnancy leave, and came back, and she had an injury from from giving birth. She had like an injury with her tailbone, and it caused her to not be able to lift really heavy boxes. Now, prior to going out on leave, prior to even being pregnant, she hadn't been lifting heavy boxes because she was a pretty slight woman, and she wasn't going to be able to lift like a 30-pound box and bring it out to stock the shelves. And so some other employee had always done that for her. She'd really never been lifting as part of her job, and she'd been doing the job for years. But this company does have a job description, and these job descriptions come up when you have these kinds of cases. You look and you see, like, what are the essential job functions? What does an employee need to do this job? And lifting over 15 pounds was listed on the job description as an essential job function. And so their position was she can't perform her essential job functions without an accommodation. And so, with or without accommodation, so we don't have to, it's an undue hardship. We don't have to accommodate it. But I pointed to the fact that not only had she never been lifting, and the job description might say one thing, but what they're doing on a day-to-day basis is actually what's essential to the job. Not only was she not lifting, but there were other employees who also were not lifting in other locations across California, some because of a disability and an accommodation, and some simply because, like my client, they were sort of slight people and they weren't able to lift these really, really heavy boxes. And it had been pretty easy for the company to accommodate them by having another employee bring the boxes out, or she could use a trolley, things like that. So that's another case where the employer said undue hardship, and we didn't buy that. And then the last case I have is an employee who was working in an office job and had very severe PTSD. And so as a result of this very severe PTSD, she suffered panic attacks. And so she would need, when she was having these panic attacks, to take a break and, be able to kind of leave the floor, take a minute, and then come back. And so she wanted to be able to take 15-minute rest breaks sort of when these panic attacks were happening. And they were infrequent, but they did happen. And in that situation, they said they couldn't, not only did the employer say, the boss say we can't accommodate that, but he used these words like she's unstable and unreliable that sort of suggested to me that this really wasn't about, the effect that accommodating this would have on the boss. It was really more about the boss's feelings about this employee having this disability and needing this help. And I have seen a real increase in like mental and emotional disabilities. I get a lot of calls about that, PTSD or anxiety attacks, those sorts of things. And a lot of these kinds of cases result in an employee asking for leave. And it gets confusing when you have these cases where the accommodation itself is leave, because under California law, there's obviously FEHA that we're talking about, but there's also CIFRA, and CIFRA gives employees the right to take leave for medical conditions, their own medical conditions, and the medical conditions of, loved ones. And so the way that FEHA and CIFRA work together can be really confusing. But essentially, FEHA says you've got to accommodate a disability, right? And CIFRA says, if an employee needs this leave, it's protected. So the accommodation itself is the use of the protected leave under CIFRA. And so you're entitled to job protection under CIFRA for a certain period of time, to 12 weeks, if your employer meets the requirements. And so that's the accommodation that the employee is asking for. They're asking to use their mandated leave as the accommodation. But sometimes that job protection extends, sometimes that employee's leave extends beyond that 12-week job protection. And then that request for additional leave can also be a request for an accommodation. Okay, I know I got my protected 12 weeks, but now I actually need, additional leave beyond that. And then the employer would have to determine if it can grant that accommodation. You'd go through, the interactive process, and you determine if that was an undue hardship to grant that additional leave. And depending on the size of the employer, it might very well be. A small employer is probably not going to be able to have an employee that's in an important job duty or important job position be gone for, a year. And so that's a little bit of how those two play together, but it can be a little bit confusing. Okay, so those are the main cases that I've dealt with fairly recently dealing with this issue. But the key takeaways for today is that the definition of what is a disability is broad, and if it impairs any sort of life function, it's likely going to qualify as a disability, and the employer is going to have to determine if they can accommodate it. I think another really important takeaway is early, honest communication is critical. The interactive process is a conversation. It's not a form, it's not a check the box. It's going to be different depending on the situation and what the employee is asking for. And I think the other really key takeaway is that most problems are solved long before we get to the litigation phase. And so if you can, engage in that process, then I think you can avoid this kind of litigation. And I have noticed that we have some questions in the chat.
I'll try to come in to help facilitate.
Yeah, because there's a lot of them, so I was going to wait. Yeah.
And we may get more. I mean, I have some myself, but I'll leave mine to the end, only if there's time. Okay, the first question we have is, what if the employee's injury is visible, broken leg and a cast? Does the employer have a duty to ask if the employee needs an accommodation?
I really like that question. Depends, right? You can go through and you can read the law, and there's no, strict answer on this. If the employee has a broken leg and the employee is able to get to work, seems like they can drive, or perhaps, they haven't had any issues getting to work, and their job isn't one where, they're limping around. They have a desk job, they're able to kind of be in an easy setup, and doesn't seem to be any problems. I mean, maybe you don't need to ask there, but I don't think it can hurt. I don't think it ever hurts if you notice that someone is injured, your employee is injured, to say to them, hey, can I help in some way? Are you having any issues? Is there anything that we can do? So I mean, you're not required to, but I do think it's probably not a bad idea to raise the issue early.
Great. The next question is, if an employee is on workers' compensation and exchanging information, is that process enough for the interactive process?
So the really complicated thing about disability discrimination is how it interplays with so many other areas of law. So we talked a little bit about how it has like an interplay with CIFRA, because that protects, gives you job protection, for to deal with like medical issues. It also has an interplay with workers' comp if the employee got injured at work. So if your employee gets injured at work, you are required under California law to have workers' compensation insurance. And so now the employee is going to go through that process. And they're going to see a doctor that's going to get paid for through, the workers' comp. And they're going to do what they need to do to assist that injury. And then at the same time, they may need accommodations at work to deal with that injury. And so, yeah, I mean, could be enough. It also depends on where the documentation is going. I have had cases where all of the doctor's notes and all of the things that are happening with workers' comp are going through the workers' comp, insurance. And so the employer is not even really seeing any of that. And so then you don't know, if there are things that are needed. But if those doctor's notes are, if all of those records are sort of going through the employer as well, then that could be sufficient. At the end of, this process, when the employee is ready to come back to work, if they've been out on leave, then you would now need to engage in that interactive process. Okay, you've given me time to deal with this injury that I got at work, and I'm back now, and I'd like to go back to my job, but I need to not be able to, lift over 15 pounds. Whatever the issue is, you would now engage in the interactive process at that point and determine if you can accommodate it. So workers' comp is just an overlay that kind of makes things more complicated, but it's not necessarily going to take the place of your interactive process as the employer.
And the next question is pregnancy in and of itself considered a disability, or is it only a disability arising out of pregnancy covered under FEHA? Am I pronouncing, is that the acronym you guys use
It
in the
is.
business?
It's
FEHA. Okay.
FEHA.
What do you
Yes,
think?
pregnancy is a disability. Pregnancy is in and of itself a temporary disability, like breaking your leg. Like at some point you're not going to be pregnant anymore, but while you are pregnant, it is a disability. And also, after you've had the baby, you still may have injuries, that are pregnancy related that need to be accommodated. So pregnancy creates a whole host of issues. And it's also, you could be very early in the pregnancy and you can have, incredible sickness that needs to be accommodated. So, it is in and of itself a disability, and the things that flow from it are also a disability.
Very interesting. And
And
I'm
there
gonna,
is a whole other,
oh,
there's protected pregnancy leave that can interplay with all of this as well. But yes, it is a disability.
okay, very interesting. And I'm gonna go back. The one person asked a few questions, so let me get some other
Okay.
questioners and then swing back and get the person's other questions. Um, when hiring, can an employer prospectively identify a disability that is disqualifying for the job? For example, a job in which attention to detail and dollars is critical. People with ADHD are not eligible for this position.
Um, it feels like a very dangerous game that you would be playing there. First of all, if they haven't disclosed to you that they have a disability and you have just sort of said this person seems like they have ADHD and they won't be able to do this job, you are discriminating based on a perceived disability. So you can be wrong or right, and that can get you into trouble. When you interview someone, if part of the job duties are being detail oriented and things of that nature, and the person is interviewing in a way that shows that they're not detail oriented, I wouldn't wouldn't jump to the fact that they have a disability. I would say, hey, look, listen, it doesn't seem like this person's detail oriented. They don't seem organized. They showed up late to the meeting. Things like that are not protected. But once you start trying to determine if this person has an underlying disability at the early stages, you can get yourself into trouble there. But there is a difference between screening for character traits that you think would make somebody a bad fit for this job and screening for disabilities. They're two different things.
Okay. If a physician needs leave from a hospital due to a legitimate injury and the medical corporation is statewide, in your experience, what is the number of physicians that would be considered enough so that the employer cannot claim undue hardship? Oh, these are very specific.
Hospital. Let me read this one because I
Yeah.
didn't fully understand that. If a physician
Yeah.
needs leave from a hospital due to a legitimate injury and the medical corporation is statewide, in your experience, what is the number of physicians that would be considered enough so that the employer cannot claim undue hardship? So, I mean, I don't have like it's 10, I don't have a number like that, but I do think that you are dealing with a high risk job, you are dealing with safety issues, you have all of the markings that can create an actual undue hardship. So it's going to depend. How big is this company? How many doctors, are in this area? What have they done in the past when somebody has needed leave? Have they accommodated it? Why aren't they accommodating it now? Is there another sort of more nefarious reason? You're going to look at all of those factors, and here's the thing: one trier of fact could say, no, that wasn't an undue hardship under the exact same facts, and one trier of fact could say, oh, it absolutely was. So, I mean, it's the law; it's messy and it's squishy, and there are just no right answers. So, in a case like that, if you're the employer, document everything. What did you do to determine if you could give this employee leave? And what did you consider when you determined that it was an undue hardship? And I would be very transparent about that. Because if there's litigation, then that's what you're going to use to show I did the best I can. If you're an employee and you're coming at this saying, hey, I don't think that this is my employer says undue hardship, and I don't think it is an undue hardship. Well, then I would look at what kind of leave have they granted to other employees in the past. How important, is your job? How do vacations work right now? When you go out on vacation, who fills in for you? You're just going to look at the underlying facts to try to figure out what makes sense.
We have quite a few others. A question, we get into another area, which is what's essential. What determines whether a job responsibility is essential? That's continuing on that last discussion a bit. And can an employer in a service industry claim that being understaffed makes an accommodation an unreasonable hardship?
Okay. So what is an essential job function? Again, squishy. There's no set answer. A job description is a great place to start. So if you've got a job description for, the position, it's in a restaurant, it's a server, let's look at what you have said, outside of this litigation, outside of this request is essential. And understaffing can result in an undue hardship. If you are a small restaurant, you employ 3 people, and one of those people needs to go out on an extended leave, that's probably an undue hardship, right? But if you are Red Lobster, you probably can afford, to let that person go out on leave. You can fill the position and still probably have a position for that employee when they come back for leave. Now, sometimes understaffing is done sort of on purpose, right? They're keeping in restaurants, they try to keep the margins really thin because it's hard to make money in a restaurant. And so I guess you could try to make the argument that you were willfully understaffing. But I mean, I don't think that's going to get you very far. If it's a small restaurant and they need the bodies to do the job, then it might be an undue hardship. Just like if you're running a restaurant and it is obviously going to be a requirement that employee be able to get the food to the table. And if that employee breaks their leg and they can't walk, and you can't keep that job open, that's not going to be a reasonable accommodation because that employee can't perform their essential job functions. But if there's a cashier position that is open in that restaurant and this employee is qualified for that position, then you at least need to interview them to see if they can take that cashier position because that would be a reasonable accommodation. So very facty.
And we're back to workers' comp again. When it's a workers' comp case and other staff is being accommodated, can they claim, whoops, it just popped up. Can they claim hardship due to the fact that they've already accommodated other staff? How can one bring up the accommodations of others since it's usually private information?
Okay, so it's a workers' comp case. And I will preface this by saying I do not do workers' comp. I do have incredible referrals for you for workers' comp lawyers if anyone needs one. But let's say that the employee is out on leave or is requesting to be out on leave. And there are 10 other employees who are out on leave for their own medical issues. Again, that could be an undue hardship now. There's only so much that the employer can financially accommodate before it's not going to be able to run its business. How do you bring up the accommodations of others? So employees know a lot. So I will have employees call me and say, I know Sheila worked remotely last year when she, had an issue with her, whatever her gout. And I know that. And, I have that information. But it's also something that you request in discovery. So one of the first things that I'm going to get out when I file one of these cases is I'm going to ask for discovery on the accommodations that you've granted to other employees. And they might not give me those employees' names and they might not lay out all of the medical issues that they have. But, I am going to be able to get discovery on the fact that you've allowed 9 other workers to work remotely in the last 3 years, so it's going to be a combination of office gossip and actual discovery that you're going to ask for in the case to figure out what's really going on in the workforce.
And the next question, this one may be a bit too detailed, and the person may just have to reach out to you directly, but I'll try to um, get to the gist of it. The person says, this is the anonymous attendee. The doctor note says, employee needs to work remotely during pregnancy.
Mhm.
Okay. If the employer cannot accommodate, then she's disabled. I'm not sure what that means exactly there, but the employer did not ask for more info. They just said, job can't be remote. Don't return until you have a note from the doctor. She knew she couldn't get that and left her position. This is very specific here. They
Yeah.
claim she voluntarily quit because she was forced to quit, but employee says to them verbally about pregnancy difficulty. This may be just too much, Liane. I'll tell you, too much
Yeah.
detail.
I
How much responsibility? It sounds like questions when they're that level of specificity with a specific. This sounds like a very specific case that I think someone should just reach out to you directly on. Is that sound?
Yeah,
Yeah.
I mean, I will say that when you are dealing with, these requests for accommodation, if the doctor's note says this person has to work remotely, end of story. That does make it difficult for the employer to engage in the interactive process, but they should still try. So they should say, "Hey, listen, we can't let you work remotely, but what we can do is offer you, to come in a little earlier and leave a little earlier, or we could modify your hours." So it doesn't take away the employer's responsibility to engage in the interactive process and see if you can come up with a middle ground. And I will say that all of these cases, these disability discrimination cases, result in the employer saying you voluntarily quit and the employee saying I was constructively discharged. That is just the name of the game because that's how it usually ends. They don't necessarily fire the employee, but the employee will say like I can't work here anymore because I can't do this job without this accommodation that you're not giving me. So it's very common for the employer to say you quit and the employee to say you constructively discharged.
Okay. Another question is, how do you handle employees who can't identify their medical condition or someone who has several different medical conditions? Just get the medical records and go from there?
I mean, I would ask for a doctor's note. I wouldn't necessarily ask for the medical records, but if an employee is saying to you, listen, I can't do this part of my job, and they don't have a reason for it. They're just saying like, I don't feel well or something along those lines. That might not be a disability, right? It has to be a disability. What is it that's causing them to not be able to perform their job duties? I mean, were they tired because they were out, late at a concert the night before? Like, not a disability, right? So, I mean, I would ask for that doctor's note. That's a situation where it is reasonable to ask because you don't understand what the disability is and what the accommodation is that they're requesting. And so at that point, the doctor's note is going to be your best friend. And they're usually pretty, clear about what it is the doctor thinks the person can't do. I think that this person can't lift and they shouldn't be lifting more than 15 pounds. And then okay, here's what they're asking for, and here's what they need the accommodation for. Can we accommodate that? Is that feasible? Is lifting an essential job function? If it is, then, it could be an undue hardship. It's an unreasonable accommodation.
So now I'm going to go back to someone who asked a question before, but let's get the person's second question. If an employee has the ability to use protected leave, why would there be a need for further accommodation, assuming that leave is the requested accommodation?
Yes. So employee gets injured. An employee goes out on protected CIFRA medical leave. The employer has to, assuming that they employ enough employees, has to accommodate that, right? But let's say that those 12 weeks of protected leave runs out and the employee says, you know what, I need 4 more weeks. Well, they don't get job protection under CIFRA. It's not automatic, but we now need to determine if that additional leave can be reasonably accommodated. Can you go another 2 weeks, 4 weeks, 6 weeks without this employee? Is that an undue hardship? So yes, you have to accommodate that initial request for leave because it's protected under CIFRA, but then they may want leave after that, which happens all the time.
Got it. And we have just a couple of minutes left. Let me squeeze in a couple items. Oh, wait a minute. Do we have a new one there? Oh, I'm going to try one more from someone else before I squeeze in anything. Post-pandemic, have you experienced claims of disability accommodation made by employees who insist they must wear masks while working in their public-facing position? Waiters, cashiers.
I have. I see it a lot. I would take the position, and there is no definitive answer here. I take the position that there are very few, I can't even think of any jobs where you can't accommodate an employee wearing a mask. I mean, we've all gone to restaurants. We've, been seated by people who are in masks. We have been waited on by people who are in masks. People have shown us to dressing rooms and given us clothing wearing masks. I think that is a reasonable accommodation, and especially if the employee has like an underlying medical condition or something and that they're very concerned about. I think that is a very minimal ask. That to me is in the category of saying like, should I get my employee a ergonomic mouse? Like, yeah, you should go and spend that $30 and buy that mouse for your employee because I think that that's a reasonable accommodation. And if your employee is saying, hey, I am, very concerned about getting COVID or getting a bad flu because I have an underlying medical condition or just because I don't want to get it, I don't think that it's a big ask to wear a mask. But I have had people call me and say that their employer is refusing to accommodate that. So, I mean, it is happening, but I think that's it's unreasonable for an employer to refuse to
So we
accommodate.
have 2 minutes, 120. Oh, 1 minute. I'll ask two 30-second questions. Attorney's fees. I didn't see something in attorney's fee. Are there any statutory attorney's fees?
FEHA has a whole statutory attorney scheme. And so, yes, absolutely, you get attorney's fees as the employee in a FEHA case.
Big, so that's very significant. And two, insurance coverage. Do you get into that ever or not? Or usually is it under specific, you have to get a specific policy and not under your general comprehensive liability?
So I am plaintiff side. So my knowledge of how insurance works is I say, does your company have insurance? Like I ask the employer, do you have
Got
insurance?
it.
And then they say yes. If they say yes, then I'm going to ask for what those policy limits are. Standard, EPLI insurance is going to cover a disability discrimination case. The only areas where insurance isn't going to apply in the employment context is like for wage and hour claims. That's often not going to apply. But employers oftentimes don't have insurance. They don't have EPLI insurance, and so you're liable.
Well, anyway, that was what a great presentation. And if there are anything else, we may have missed one question there. Someone can of course contact Leanne directly, and maybe she could help with your specific issues. But thank you, thank you, thank you. What a great presentation. Boy, I learned a lot, so I'm sure everybody else did too. So thank you, everyone in the webcast audience. We had a great turnout. Thank you, Leanne, again, and
Thank
see
you.
everybody else at the next program, which we're planning for January. Okay, okay, bye now.